A family trust is one of the most common ways of holding assets, holding shares, and running a business. Family trusts are used thousands of times throughout the great country of Australia. But what happens when you want to change the succession planning of the family trust? So what happens when you want to hand across the power of the family trust? Maybe you're dead. Maybe it's time that your children step up and start running the business. Today, we are going to look at the succession planning of doing a deed of variation of your family trust to allow succession planning to take place. My name is Professor Brett Davies, and I'm a barrister of the High Court of Australia and a partner at Legal Consolidated Barristers and Solicitors. There are many types, 4 ways to update your family trust deed, and there's training videos on all of those. My preferred option is that you do a deed of variation which updates everything, but if you decide you only want to update the appointer clause, that is fine as well. So let's have a look at the nature of a family trust. There's 2 main players. There's a trustee and there's an appointor. The appointer is God. The appointer controls everything. Oh, but Professor Davies, the assets are in the name of the trustee. The trustee looks like the big important person. That's true, it does. And that's so important for tax law. Under Australian rules, you are better to control an asset than to own an asset. Because the guy that controls it. The guy that owns it's got to pay the tax on it. So there's a real dissonance between controlling an asset and owning an asset. For tax, bankruptcy, family court, everything. It's very important to distinguish between who controls the asset and who owns it. So let's have a look at a family trust. The person that controls a family trust is the appointor, not the trustee. The trustee is just a squash cabbage leaf, because God, the appointor, can sack the trustee any time appointer wants to. Now, neither own the assets. The assets are all owned by the beneficiaries of the family trust, of which there's thousands. There's 38,000 registered charities in Australia. They're all beneficiaries of your trust. If you've got shares in Rio Tinto and they've got 350,000 shareholders, they're all beneficiaries of your family trust. It's not just you and your children or your distant great-great-grandfather or great-uncle or someone living in another country you've never met. It's not just those groups, but it's a huge grouping of people. Potentially 300,000 to 400,000 people will be a beneficiary of a family trust. But I'm not interested in that. I'm interested in fixing up and making sure that the structure in your family trust is correct for the next generation. And it all comes back down to the appointer clause. So we are today going to amend the appointer clause. As with all our documents, there's a full sample which sets out what the document will look like. Obviously, your document will look differently depending on how you answer the questions. There's a checklist so you can see the questions to be asked. And there's also an extensive introduction page which gives you advice on different matters. So, for example, your family trust might be quite old and might use the expression controller or governor or principal or guardian. And they're all just the controlling words. And it doesn't matter, our document will deal with that. Can the appointer be a company? Yes, it can. Should a 3-generation testamentary trust or a testamentary trust or a will control your family trust? Now, this is the biggest mistake people can make in Australia. They confuse the family trust with their will. They think they go to their will and say, look, I understand that these family trusts go for 80 years. In South Australia, they can go forever. I understand that. But upon my death, I want the trust to be under the command of my 3 children. You don't do that in your will. Your will is a grubby little document that can be challenged. You do it by doing a deed of variation of the appointer clause, which is exactly what we're going to draft today. You change the appointer. Don't let the will control your family trust succession planning. Do not. I don't care that your family trust deed says, and upon the death of myself and my spouse, the children will be the appointors. That That's not what should be in the will. That should be in the family trust deed. So the family trust deed should not refer to a will. I know a lot do, but it's wrong to do it that way. So let's have a look at, the other interesting thing is, what if my children are under 18 years of age? Still appoint them as the appointors, and during the time they're under 18, there's powers in the deed of variation for the next of kin to look after the affairs for the best interest, for the very best interest of those little tiny tots. Now, I'm going to start building the deed of variation of a family trust to update the appointor. Now, the appointor can be and should generally be you and your spouse. So in my case, it would be myself and my wife. Oh, but Professor Davies, doesn't that destroy your asset protection strategy? No, not at all. The appointor can be both myself and my wife. I'm a high risk. I'm a part owner of a business. My wife's a primary school teacher, so she's at no risk. You can still make both of us the appointors, because if I suffer an insolvency event, I'm immediately removed as the appointer automatically without reference to anything, and my wife remains as the appointor. So these days, because of the way that Legal Consolidated drafts the family trustees with all those get out of jail card provisions, so if you're suffering something, you're immediately removed as the appointer. That's not just death, it's not just bankruptcy, but also of unsound mind. And it would, if I lost mental capacity, my wife would be the remaining appointer. So here, let's start. I can pick up the data from a previous. Why don't I pick up here's a family trustee update. I'll pick up the data from that document, and it's put in the details of my trust. I've changed the name of my trust now. It's going to be called the Davies and Smith Trust, and the settlor is my old accountant who's dead. I put in his last known address before he died. The trustee is currently a company. Fidget nominees, PTO Ltd. So I'm not changing the in this document, I'm not changing the trustee. I could, but not in this document. There's the trustee. I've only got one trustee. It's a corporate. The appointor that's leaving is no one's leaving. I'm currently the appointer. The appointer that's staying is me. I'm going to add my wife as the second appointer. So the current appointer is me, Brett Davies. So I'm the appointer that's staying. The new appointer will be my wife. Mary Lou. So I'm staying as the appointer. My wife's coming on as an appointer. Therefore, used to have one appointer. Now we're going to have two appointers. Now we're at the question of the backup appointers, and this is your succession planning. My doctoral thesis on succession planning is a great deal of interest to me. This is the proper procedure to follow on succession planning for a family trust. And this is where you put in the appointors, the controllers. Forget about the trustee. It's just a squash cabbage leaf. This is where you put in who will control the trust upon your death and your wife's death. Now over here is some hints. On all our documents is hints. So what's the difference between a trustee and appointer? We've done that a bit. And what if I've got 13 children? Then children in. Now the backup appointors are human, and I've got, say, 3 children, and I'd put in the names of all the children. I'll just keep adding and adding another backup for my second child. You get the hint. I could put a third one in, but I'm not going to here. So in this case, I've now got 2 children. They will be the appointors after my wife and I die, or suffer mental incapacity, or whatever, bankruptcy, whatever. Now notice I've got green ticks. I can't proceed further until I get green ticks. In fact, I will not see the lock and build button until I get green ticks, and I've got lock and build. The logic flow of this document belongs to Legal Consolidated. We, as your lawyer, are responsible for it. So it's critical that it be correct. So now I'm just going to check everything. Davies and Smith Trust, that looks correct. Correct spelling, yes. I'm happy with that. So if I need to amend it, if I made a spelling error, I could just email the law firm. They'll give me a voucher to update it. It will come as a locked PDF, so you cannot change it, but we can give you a voucher to update and update the document, but through our system again, because we, as a law firm, as your lawyers, are responsible for the document. So let's press lock and build. I'll put in my credit card details. The document is emailed to me, and I can also access it from our website, which I will do. Your data and your information is stored permanently on our law firm's record. So you can log back in, or when you die, your children can log back in to a username and password and see the documents you've built through your entire life. Powers of attorneys, 3 generational testamentary trust wills, or whatever needs to be done. So here it is, Family Trust Appointor Update. It's there's the data. So if you want to use the data again, you can. We never destroy your data, so you can always come back. But here's a locked PDF. It's locked, so you cannot change it. Let's have a look at what you've built. Law firm's letterhead, signed by a partner of the law firm. It's addressed to God, the 2 gods. What's a god? That's the appointor. The trustee is a squash cabbage leaf of no interest as far as the power of a family trust is concerned. It's how to print the document. There's the minutes, and there's the deed, changing the appointers. This is a succession planning document. My preferred option is you build the everything family trust update, so you're updating the deed as well. Deeds go out of date, but in this instance you've decided just to build the clauses to change the controllers of the trust when your appointors die. There's a remaining appointor, new appointor. The appointer that's staying is me. The new appointer is my wife. So now Brett and Mary Lou are the current appointors. Do they have to act unanimously? Yes. Under our trustees, and it's the correct procedure of drafting a family trust is the appointors have to act unanimously. What's that? You're worried that the appointors, so you've got 3 children, you're worried that they may not be able to make the decision if you have 3 appointers after you and your spouse die. Well, that's good. That's good they have to act unanimously. Why? Because if you gang up, if 2 of the children gang up, they could take and if the appointers could act by majority instead of unanimously, if they act by majority, then 2 can gang up on the 3rd, and the 2 of them could take 100% of the capital income out of the family trust. So they have to act unanimously. And have a look at your trust deed. And that's why you should have updated the entire trust deed as well, so you have all the correct rules and regulations. So Brett and Mary Lou are the appointers, and the backup appointers are the 2 children, Jack and Joanne. When I die and my wife dies, those 2 people will be the appointors in full control, acting unanimously. What? If they fight, they go to court. But no one wants to go to court. Tens of thousands of dollars go to court. So the children have to decide together what they need to do. And there it is. I'm signing off as the appointer and my wife signing off as the new appointor. You have today built a deed of variation of a family trust, which can change the appointors. You might have made a company the appointor, and also inserted backup appointors, therefore removing the family trust's beautiful, pristine document out of the clutches of a will. A will is no place to try and deal with succession planning of a family trust. I hope you've enjoyed this training video on changing your appointors. Enjoy using the law firm's wonderful services.